Welcome to the Western PA Work Injury Podcast.
Welcome to the Western PA Work Injury Podcast with attorney Michael S. Russell. With 33 years of experience representing injured workers across Western Pennsylvania, Michael focuses on helping clients navigate workers' compensation claims and protect their income and benefits after a workplace injury. I'm Leann Lyon, and today we are talking about what happens when workers' compensation checks stop in Pennsylvania and what injured workers need to know about protecting their benefits. Hello, Mike. It's nice to see you.
Good morning, Leann. Nice to see you as well.
So, Mike, once somebody starts receiving workers' compensation benefits in Pennsylvania, can those payments suddenly just stop?
Short answer to that question is yes, they can suddenly stop in certain circumstances, Leann. In our prior podcast, we talked about the ways in which work comp is recognized in Pennsylvania. We have a process called a notice of temporary compensation payable that lasts for the first 90 days. During those first 90 days, yes, indeed, there are many times where an individual will start to receive benefits and then they essentially stop overnight. That's the purpose of that notice of temporary compensation payable, is it gives the employer the opportunity to do some investigation. In the old days, they had to either deny it or accept it. So they would typically just deny it because they only had 20 days to make a decision. So they would typically just deny it. And they put this process in place with the NTCP that allows them to accept an injury, start paying the injured worker, which gives them some funds to survive on. But then during that 90 days, they get to investigate. They might try to get somebody back to work, or they might just decide that this is not a work injury that we're going to pay for, and they could shut those benefits off. Conversely, if you're already on comp and you've been on comp for the 90 days, your case converts or is recognized by something called a notice of compensation payable. I get that we've now removed the temporary. In those cases, ending of benefits is much more difficult for the insurance carrier, and there's typically going to be some things that are moving forward and happening in the case that are kind of signifying that things are going to get into litigation and you may lose your comp. However, there are many, many occasions where people in a permanent compensation situation have their benefits cut off. 99% of the time, it is simply an accident. If it's not an accident, the comp carrier is in trouble. There are processes in the background running for these compensation carriers where they have to do certain things. Sometimes the claim adjuster might have to go in and punch a button every 60 days to signify to the system that the benefits need to keep getting paid. Sometimes they forget. They tell us it fell off the list of checks to be paid. I can tell you, Leann, that me and my assistant probably field, never counted, but I bet it's 20 or 30 calls every month of people whose check that didn't arrive or their direct deposit didn't come in. 99% of the time, it's just a glitch. We send an email out, we call the adjuster, we call the attorney if they're involved, and they realize, oops, fell off the auto pay. They stick it back on auto pay. And we get that issue resolved. If they don't, then we file petitions and we end up in litigation, and they have to justify why they stopped benefits. And that's typically not anything that you're going to be surprised by. If they're stopping benefits and we're in litigation, there's some things that have happened that have kind of let us know that thing's coming. So I sound like a broken record in these podcasts. Whether you're getting benefits 2 weeks out, 2 months out, a year out, you need an attorney involved. Just for these kind of instances where your benefits are stopped, it can be taken care of by a claimant. But as we'll talk about probably in the course of this podcast, you need a lawyer there giving you some advice and directing you, because the reality that I tell every single client is they're never going to leave you on comp forever. They're never just going to let you keep getting your checks. They're going to try to find ways, and they're entitled to find ways to limit your receipt of comp or end your receipt of workers' compensation wage and sometimes even medical benefits.
I have to ask the question, when you say they, are you talking about the insurance companies or the actual employer usually?
The employer in Pennsylvania is typically relatively uninvolved. Work comp insurance in Pennsylvania is an insurance policy that every employer is mandated to have that covers their employees in the event of an injury. So Usually I'm dealing with the work comp carriers. I use employer, carrier, and them kind of interchangeably because the defendant is always the employer and the carrier.
So beyond just an accident, we forgot to push the button, what are other main reasons workers' comp checks can get stopped?
There's a whole list that I can go through here at this point, to be honest with you. Again, I always tell clients it's not going to happen overnight, which is, again, why you need an attorney. You need an attorney. I mean, we talk to our clients about building a case. That case can be building a case to put you on comp because they haven't accepted your injury, or it can be building a case to defend what we know is coming. And typically, we're going to know it's coming before it's here. And so many clients over 33 years have called me, and their case is all the way down here, when they needed a lawyer back here to start directing them to do things in order to prepare for that fight that was coming. So again, there's lots of guideposts, I'd say, that tell us that a comp claim is getting to the point where something's going to happen. Oftentimes that depends on the condition of the client. If my client's getting better, if their own physician is showing a progression that seems to indicate that they're getting better, likely something's coming. But there, in terms of actual things that will result in the end of benefits, number one is a return to work. That's one of the easiest and most common ways in which an employer is trying to limit their receipt of workers' compensation benefits. So we have light duty returns to work, full duty return to work, light duty with no wage loss, light duty with wage loss. So there's lots of different things that can happen there. If you're released by your physician or sometimes by one of the employer doctors to a light duty capacity, oftentimes and more often than not, the employer is going to offer you a job of some sort to meet those restrictions. Whether the job actually meets those restrictions is often something we fight over. But they're going to try to offer you a job that pays you either at what you used to make before your injury or some amount less. If it's less, they owe you 2/3 of the difference in workers' compensation. So any return to work is going to impact your entitlement to wage loss benefits. The mechanism for that process. Well, actually, before I get there, I guess we'll talk about if you're released full duty. If you go back to a full duty job, more often than not, and that not even more often than not, that's going to end your entitlement to comp because we are a disability state here. We pay clients based upon their loss of earnings because of the injury. So when you are released full duty and you go back to work in a full duty capacity, even if it's at a wage loss, if the employer has had an economic downturn and they bring you back making $500 less a month, there's no payments at that time because your benefits are suspended because you're released full duty. Mechanism for that is typically something called a notification of suspension. It's simply a form, the employer fills it out, they send it to you. And one of the things that we see frequently is the carriers, I would suggest not on purpose, but oftentimes they'll just issue a blanket suspension. And my client's back to work at a light duty status. He's losing money every week because he's still got a disability there. And they just issue this notice that says, actually, I have this right now, this exact case. They issue a notification of suspension without acknowledging that that individual is working, making less money. And so he's not getting paid properly. I had a client call me literally yesterday who got a notification of suspension, didn't tell me about it, and called me on the last day to file an appeal. We have 20 days to file those. It's a very limited time frame. So we have to challenge that notice within that 20 days, and we'll end up getting his case in court. He's at a wage loss. They suspended him, so we'll be able to get him back on workers' comp at his partial disability benefit rate. Offered jobs. Again, sometimes they'll offer a job. My client might not think they can do it. Sometimes it's a full duty job. Sometimes it's a light duty job. In those cases, more often than not, I have a doctor on their side that says my client can work. My doctor on my side says, no, I don't want him working, or I want him working at light duty. What they will then do is offer a job mostly consistent with their own physician. And you need to have a lawyer there telling you how to handle that job offer, how to handle your return to work. Beyond actual job offers, there's other ways that they can limit your benefits. They can file something called an impairment rating evaluation after 2 years of wage loss benefits. They can have you examined by a doctor that's appointed by the Commonwealth of Pennsylvania for something called an impairment rating evaluation, which looks at your diagnoses, comes up with a whole person percentage of impairment based upon your injury. If that impairment is 35% or less, you're now on partial disability. And while your benefits don't change immediately, they cap your benefits at 500 weeks. The other thing is they might have a doctor that says you're recovered. So that's where we end up getting into a litigation. They file a petition. Their doctor says, my client's fine, recovered. I have a case right now where their doctor examined my client, said my client was recovered fully and completely, and 2 days later, he's having surgery with another doctor. So those are some of the typical things that we're dealing with. Again, nothing should happen overnight. And again, broken record. That's why I tell clients all the time that call me and they're just kind of feeling out the issues. They want to know what their rights are. And I tell them just about every time, if you have a comp claim, you need to get a lawyer on your case. You need to have somebody. I actually tell them, I'm going to step in between you and that compensation carrier so they can't get to you unless they go through me. And so we know if they're scheduling an IME, we know if there's potential job offers, we know when to start doing the things so that we don't get into court with no fight available. Because if you get into court and you don't have any evidence that says you can't work and they offered you a job, judge is going to cut you off comp in 2 weeks. 2 weeks is not a long time to be able to get a defense ready to fight that case. So there's lots of ways, but they take time.
Got it. So, based on what I just heard, it sounds like people do receive notice before stopping benefits, at least after a certain period of time, and that the checks can stop even if the injury is not fully healed, correct?
Absolutely. There's not a notice per se, like they don't send something out that says we're going to, absent those mistakes and absent the first 90 days, we'll get beyond that. Once we're talking about somebody that's on comp, um, what's going to happen typically is an exam. So they're going to send my client to an exam. They want an opinion on a number of different issues to determine whether somebody's able to work and then, or whether somebody's recovered. And then the notice we get is they get an IME report, they file a petition. Once they file a petition, we have to respond. That case is now heading to litigation before a workers' compensation judge. First hearings typically in about 6 weeks at this point. And then we have a series of a number of different hearings until the conclusion of the case when the judge makes a decision. This individual has recovered, this individual can work, or this individual hasn't recovered and can't work. And indeed, you can be not fully recovered. You can not be capable of working in your opinion and in the opinion of your own physician, and you can still lose your benefits. But that's going to be after the conclusion of litigation. But again, the key is if you go into that first hearing 6 weeks out from that filing and you haven't done the things to prepare to protect yourself and to protect your benefits, the judge after that first hearing in 14 days issues a supersedious decision. It is an interlocutory order, and the sole purpose of that order is to determine whether that individual's benefits continue while we litigate. Again, litigation is going to take about a year. And if the judge grants that employer's request for supersedious, that means benefits end. You're now off comp and we're fighting your case, and we've got real problems at that point.
So, if somebody's check stops unexpectedly, what should they do right away?
Well, again, if it stops unexpectedly, they better have a lawyer. If they're without lawyer, they're going to call the comp carrier. But again, it's always my recommendation that somebody has an attorney so that the attorney can jump into the middle of that dispute and address it and deal with it. In cases where we're heading to litigation, I can't tell you, Leann, how many, I'd probably say thousands of clients who have called me over the years Hey, Mike, I've got a hearing next week. I want an attorney. And so we begin to
Yeah.
talk about the status of their case, their medical treatment, what kind of doctors they've seen. Some of those people are not even seeing a physician. I have a client right now that we're trying to settle his case, called me. He's been on comp for 3 years, but hasn't treated with his doctor for about 9 months. And they did an exam. And so now we're in a position where we do not have the medical evidence to say, wait, this guy can't do that job. So the important and the most important thing is to be prepared for those times when your benefits are going to end, when a petition's going to be filed. So I guess my answer to your question is get a lawyer, have a lawyer in place. If your benefits stop automatically, that's typically going to be resolved with a few phone calls and emails, and your check's going to be put back on. No big deal, no problem. Where it's a problem is where things have been coming to a crescendo. You've been recovering. They've scheduled you for an exam. You've seen their doctor. Your doctor has released you to return to work. So on and so forth. Or you've been offered a job. Clients call me. My doctor released me to light duty, and I was offered a job, and they offered me a job, and I didn't want to go back to work for them, so I didn't go back to work. Nothing I can do for you. Your wage loss is going to end. So a good lawyer that's seasoned in this is going to direct you in how to respond to job offers. So being prepared for those upcoming petitions where something's coming down the pike, and being prepared for those is critical. And also at those points, we start talking as I see my client's condition improving. He's getting better and better. As an attorney who's done this for so many years, I know that pretty soon, because the employer gets all those records every time you see your doctor, they send a bill off to the comp carrier, and the law requires that the doctor send a copy of his records. So they see in those doctor's records that this individual's doing better. His exam's better. He's able to do more things at home. He's able to walk better, so on and so forth. So they see this progressive improvement in condition. And at some point, that's going to trigger them to say, okay, we need to get an exam because we want to know what our doctor has to say. And so I know that's coming way back here. But if you don't have a lawyer, you're not ready for that. So we start talking about settlement as we see that client's condition improving. We're going to start talking about, hey, do you want to settle this case? You're getting to the point that you're going to be released. Do you want to go back there? Do you want to find alternative work? So we're preparing, we're talking about those issues as we see the improvement coming.
Well, that is it for today's episode of the Western PA Work Injury Podcast. If your workers' compensation benefits have stopped and you're trying to understand what options you have, you can learn more or get in touch with attorney Mike Russell at attorneymichaelrussell.com. And thanks for listening. Remember to subscribe, share, and leave a review so more injured workers in Western Pennsylvania can find the information they need. Thank you, Mike.
Thank you, Leann. My pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.